network has us rolling. I want to welcome everybody to the Zoning Appeals Board for today, July 20th, 2023. I'm going to go ahead and ask everybody to please either turn off or silence your phones. We have a couple of preliminary announcements before we get started. There are 2 items on the agenda today that are going to be deferred one meeting. The first one is 2023-52. This is a request to reduce the side setback from 10 feet to 5 feet for property located at 512 Berrywood Drive in the RS20 zoning district. Was anyone here to speak on that case? I don't see anyone. And 2023-73, that's a request for a special exception to reduce the street setback and the rear setbacks for property located at 3509 Charlotte Avenue, zoned CS. I know the applicants are here, and was there anyone else who was here, any members of the public that were wishing to be heard today on that one?
On the Charlotte?
Yes. Okay, we're not going to have the public hearing today because that one's being deferred one meeting. Would you, and so.
Can you wait on that one, or can I tell you, can we discuss that one?
So as far as deferring it, do you want to be heard on the deferral?
Yes.
Okay, Madam Chair, if I would, this is Councilmember Kathleen Murphy.
Thank you. So I was not aware that this was going to be requested to be deferred. That's probably because the community meetings and the applicant here have not properly been coordinating the community meetings with me. So first, I heard of a community meeting for this one back in early July. There was, or in late June, I think there was a meeting held that was across the county from my district. So my district is West Nashville, so think like where Climb Nashville is on Charlotte. The meeting was being held at a Mexican restaurant on Gallatin Road past East Nashville, and that letter had a BZA meeting date of the 6th, so that meeting was not appropriate, that letter was not appropriately done, nor coordinated with me. And then this past on the 15th of this month, I received an email from the applicant letting me know that they would like to extend an invitation to me for their community meeting, which was held on the 18th, just 3 days later, during a council meeting. So there's no way that I would have attended. Your rules state that the community meeting needs to be coordinated with the council member, and so technically this should be denied. And what I guess I would ask of you is the new councilwoman, the councilwoman who's replacing me does not have opposition. She was going to be here today, but got a flat tire on the interstate. So it's just comedy of errors in District 24 right now. So I was going to ask that maybe what would be fair is to defer this until November to allow the new councilwoman to be able to do this. But really, it should be deferred. I wanted that in the record, that it was not following the rules at all. But I think, this is I would also like to add to the record that the notice sign for the BZA meeting, the grass on the property is taller than the sign. So the sign isn't really visible unless you're looking at it directly in front of the property. And so this really isn't noticed appropriately across the board. So I would ask that y'all either deny this or that you defer it until at least November so the new councilwoman can call a community meeting and work with District 21 is a very close line here, and I'm sure Brandon Taylor would like to have some input as well, but he has a new baby, so he's been taking some paternity leave. So at the will of the board.
Oh, yeah. They do turn on and off. There's a green light.
Mm-hmm. Thank you for clarifying. Do we have any questions for the councilwoman of the board?
Is the applicant here?
Yes.
Okay.
Were there questions?
I guess, I would like to know if there's opposition from the applicant to deferring it to November, but.
I'd almost rather, since they're obviously not done anything right at this point, I'd rather deny it and have them come back and do it right the next time.
Well, I think we're not on the part
I
where
know,
we're
I
deliberating
know.
about the case, so the case would need to be introduced. But we don't want to hold up the councilwoman.
And I'm staying for another case, so
Okay.
that's fine too. Whatever y'all want. I've got plenty of work I can do in the back quietly.
Sounds good. I think we'll keep it in the order it's on the docket, but thank you for your comments. Other
Are you
questions?
the applicant?
Yeah, well, we'll have to hold until it's placed on the docket.
Okay, I guess on the deferral. Cool, okay, yeah,
Yeah.
that works.
Or you can take the other one, can't you? 52, just defer 52 without objection, and then we can come back and ask again, Madam Chair.
I'm sorry, your question is about, well, 52 is already deferred.
Yeah.
Right. Okay, so I think we're ready to start.
Thank you all. So for the remaining cases that are on our agenda today, we're going to call each case up in the order that they appear on the agenda. All but one of those cases is set for public hearing today. The second item on the agenda is not set for public hearing. That's case 2023-50. That's a petition for a rehearing, and so we will certainly discuss that case. But for the matters that are on public hearing today, we wanted to provide notice to everyone who's here to speak, either in favor of or in opposition to a case. The way that our board procedures work is that each side has a total of 10 minutes to make their presentation. First, we will submit slides including maps and the site plan for the board to see. They'll also appear on our monitors for everyone to see. After that time, the applicant will have an opportunity to make their presentation. They have up to 10 minutes, and anyone else who would like to speak in favor of the case may also speak at that time, but everyone has 10 minutes total, and the applicant may also wish to reserve some of their 10 minutes for an opportunity to rebut any of the opposition testimony. Once that portion is concluded and their presentation is done, we'll call on any members of the public who wish to speak against a case to come forward. They'll have a total of 10 minutes. So if there's one person or if there are 10 people who are wishing to speak against a case, then you might want to discuss amongst yourselves how you want to divide your time accordingly. And then after the close of the opposition testimony, we'll hear from the applicant again if they had reserved some of their time in order to respond to any of the statements that were made during the opposition portion. For any cases where no one raises their hand wishing to be heard against a case, then actually the applicant in that case, where it's an uncontested matter, will have 5 minutes total to make a presentation in which they may explain any of the statements that are in the application, as well as why they're here before the board today. And at that time, the board will deliberate on all cases. It takes 4 votes for the board to be able to grant an application. And once a vote is taken on an application, a party who disagrees with the outcome may request a rehearing within 60 days. Parties may also appeal a decision to the Davidson County Chancery Court by filing a writ of certiorari within 60 days. All parties are encouraged to seek independent legal counsel before filing an appeal to ensure that all deadlines and procedures are followed. Whenever we take any statements from applicants or parties wishing to speak against a case or in favor, you'll come up to these microphones here. The microphone should already be on, and you'll just state your name and address before you make your statement to the board. With that, we will begin calling through our cases on the docket. The first case today is 2023.
I'm sorry, I meant to get with you. I had to step out for a second. Preliminary, members, I've been talking with our legal counsel. Case 72, which is the case of Lotus Building Group at 914 Southside Place. Is the appellant present for 914? Are there any parties present opposed to this case on 914? We will need to remove this case from our agenda. There's actually a procedure to request ADA accommodations outside of this process. So I'll get with you after Ms. Waits starts the next case, and we'll talk through the process of doing that. It's not it may require a public hearing, but it may be approved with just public notice, with the possibility of an appeal here. But I'll talk with you about that one. And then members, board, when the time comes before case 50, I'd like to address something with you on that case specifically. So.
Yes, thank you. That was what I wanted to ask the board at this time. We have some council members who are present, and I believe at least one of them would like to speak to you now before we have our public hearings, and then we will ask Councilman Mendez and Councilmember Murphy if they would also like to be heard on any of the cases that they are here for today. So at this time, I believe Councilman Pulley would like to be heard on a case in his district.
Thank you very much. I appreciate your service as always, and I just wanted to speak very briefly on case number 2023-007. It's the Green Hills Child Development case. I just wanted to say that I did meet with the applicant on site, and I did look at what it is that he's asking the board to do, and the only thing I wanted to appeal to the board to consider here is this is a child care development center, and they're very, very concerned about security, and in light of all the current events around school security, that's obviously a heightened issue for us in the community as well. So to the extent that you can take into account the impact on the security of his school situations as it relates to this variance, I'd appreciate that. Otherwise, obviously this board is filled with great people who are very thoughtful and considerate, and I appreciate your service, and thank you very much for your time.
I have a question.
Sure.
In reviewing the packet, it appeared, and we'll have the hearing later, of course, but it appeared that the fence was a 6-foot solid fence. Do you see any way there could be a 6-foot fence that was partially solid and also somewhat transparent, like a...
I think that question is better asked of the applicant because I think in the total security aspect, which includes his ingress and egress, this whole variance is related and tied together with that. So I think it'd probably be better for him than for me to answer that question.
But you're in support of the variance as requested?
Well, I just wanted to make sure that you considered school security in your thought process. That's what I'm asking you to do.
Okay, thank you. Any other questions for the councilman? Okay.
Okay, I believe the remaining council members will prefer to be heard in the due course as each of those cases comes before the board. So first, I'm sorry. Okay, yeah.
Because honestly, I think this one, if y'all are doing a consent, could probably do that. So this is case number 2023-079. So it's 5420 Knob Road. And I am here to represent my constituents who are the applicants. We have a neighbor, and then the applicant's son, which is also Councilman Bob Mendez, who is here as just a son today. So it's my actual one chance to speak for him. So y'all take a seat and we'll be here. No, I'm kidding. This is one where, as you'll hear or see in the packet, their house was struck by a truck, and this is a simple variance to just kind of get their house back in order. And quite frankly, I'm very thankful that they chose to stay in their home. This is an area of my personal neighborhood that has seen some rapid redevelopment and things, and I know that they probably could have cashed out, moved on, and something large come back in that wouldn't be in character with the neighborhood. So I appreciate the fact that they were willing to rebuild and stay put, but they've gone through an awful lot of insurance mess with all of this, and so we're asking that you grant this. No one in the neighborhood has voiced opposition. Like I said, our former neighborhood president is here to speak in favor of it as well. So we just ask that y'all, if you have a consent, move it on out to save everybody time, or please approve when it comes up on your agenda.
Thank you. Any questions for the councilwoman? No. Okay.
Okay, thank you. And if I may, I would like for us to maybe take a moment until the zoning administrator gets back before we start this case 2023-75. So I'll go check in with him really quickly. Okay. Case 2023-75, this is a request for a special exception for property located at 6201 Hickory Valley Road, also known as Hillwood Country Club, located in the RS40 zoning district. This case was on public hearing at our last meeting on July 6th and was deferred to today for further consideration. We would like to ask the board to reopen the public hearing. I'm going to go through the slides again. We have some clarification on site plans and the requests that are before the board, and we would also like to incorporate the public comments that were heard last time. I'm not sure if the neighbor who spoke to you all last time is here today, so we will also consider those comments. And here's the zoning map of this area, an aerial view. This is a larger aerial view, including the golf course. This is the entrance to the country club. And then this is the drive aisle coming in from Hickory Valley Road. This is the golf course, and then to the right is one of the buildings, tennis courts. This is the building that was there next to the golf course. And then it wraps around. This is the eatery behind, and another shot of the entrance back there. And then adjacent to that section that we were just looking at, these are the pool area. And then another view of the golf course. And then this is the golf cart storage area, which is one of the buildings that's being proposed for new construction. It's a copy of this site plan, and then there's one that you can see closer in as far as each of the changes that are being requested as part of the special exception. And there's also a request for a variance to be able to encroach into the 100-foot setback. There's a 100-foot setback along all boundary lines for the country club. So with that, did you want to speak at this time?
Yeah, happy to. Members, I appreciate your service here. I wasn't able to attend last meeting, but I think some questions came up about pickleball versus tennis and uses. I wanted to cover that if you had any specifically, but at least my watch of the case. What currently sits where the proposed pickleball courts now are existing tennis courts, and to me, there's no change of use occurring here. We're not going from country club to rec center. We're not. It's still country club use, and from my standpoint, the change or the restriping of that would be permitted under its previous special exception uses. So they're not really asking you per se to approve that change. What is being asked of you today would be the addition of the golf cart building, the tennis center, the adding of the golf studio. I think there's a gatehouse out there. All things under there that were not on the prior special exception approval from this board, and you are being asked to approve those. Of those additions, the tennis center is encroaching in the 100-foot setback under today's regulations of the SE. So that is before you. But the prior, let's say they were they were truly adding tennis facilities out here to it, those would be asked under the special exception. But in the instance here, the change from one athletic sport to another, that's not before the board as far as seeking approval. They could change that. They could go to ping pong, or they could go to racquetball, outdoor, if there is such a thing as outdoor racquetball. Volleyball, let's say they put a volleyball pit here. Those would be okay for us under the code. If they're adding facilities that were not there, then that would be part of their special exception ask. Adding say instead of looking at the site plan that's on the screen there, if we were to add 2 or 3 basketball courts that weren't there, those would be part of the original ask. So I hope that clarifies any confusion as far as uses that might have came up or in the testimony. Again, I did not see the entirety of the testimony. I wasn't present. But just kind of give you a little flavor of how we sort of treat country club versus YMCA rec center or something of that use.
A question, if you don't mind taking it now. I'm trying to remember from the last hearing, there were 3 variances, and the planning department, I think, took 2 of those variances out of the equation. And I wanted to see.
Landscape buffer yard would be required along portions of the additional structures in that property line. Now, to the extent we've been actually, Metropolitan and I have been investigating case law of other special exceptions over another issue, but to the extent that this existing use does not comply with today's standards, they are grandfathered from those standards. Any additional expansion of it would need to comply in that. So
I think the lot area and also not being on a collector street were the other 2.
Yeah, those 2 for sure, in my mind, are legally non-conforming to those. Hillwood Country Club exists on 2 parcels out here, both owned by the facility. What you see, the red boundary kind of cutting through the backstrop. For the purposes of zoning, I'm treating that all as one parcel. So I'd apply setbacks from the exterior larger tract that's there, since it's all the same use that's occurring.
So the sections that are asking to encroach into the 100-foot setback, there's, if you look on this proposal, actually, I think that's...
Yeah, that slide back there is probably probably one of the better slides that shows it. The tennis center marked out kind of in the bottom left corner is encroaching in the 100-foot setback. And the gatehouse on this portion, the proposed cart building where it shows the red line cutting through it, again, disregard that. That's the common property line that they own both parcels. And I think those were the... Maybe you're...
Yes, okay.
Yeah.
It's, yes, the blue line, and so the yellow building at the bottom left, which is labeled Tennis Center, if you look closely, and then I've also got a printed copy of this site plan on your desk, and so there's a portion of the building that the applicant can speak to what the actual dimensions of that are, that is proposing to encroach, and then, as Mr. Hargis said, also that gatehouse at the front. And then you'll recall that there's a drive aisle in the front that doesn't have a gatehouse right now. Okay, all right, at this time, if the applicants would come forward, please, and you'll have up to 10 minutes to make your presentation. Any time that you don't utilize will be applied toward a rebuttal period after the other gentleman speaks. You can sit down over there. Thank you.
Good afternoon, Commissioners. My name is Jeff Hooper with Bard Civil Associates. I, as well, was absent last 2 weeks ago. We are requesting a special exception and a variance for actually 4 structures on the course.
Sorry, could you state your address?
Sure. 6606 Charlotte Pike. There's actually 4 structures, 2 of them that you see on the slide at this point, which is the first one in the lower left-hand corner is a tennis facility. That encroaches of approximately about 25 feet into the setback. The one for the gatehouse, it's a small 400 square foot type building that is there for security purposes. We're going to do some perimeter landscape upgrades and fencing upgrades. And so that's for control of members and guests in and out of the facility. And there's, on the previous slide, there's actually 2 comfort stations that was presented to this board about 3 years ago, if I remember correctly, that were approved. That case has since expired, so we're asking for those 2 facilities to be able to be reconstructed as well. Other than that, I'm here to answer any questions.
I think it would be helpful just to go through, so we went through, that's a special exception part, maybe to go through the 3 variances that are listed and let us know whether or not you still need to request those variances.
So the variances of the setback, obviously we are requesting. The other 2 variances, I'm not sure what you're speaking to.
Yeah.
Sure.
Yeah, for clarification for the board, the street access and the the street access for sure is not a variance request. They are legally non-conforming to that. If they were putting in new roads or something into the site, then perhaps, we would look at those. But that's an existing condition. So for the record, we'll remove the street access variance. Landscape buffer may actually be in the same course. If looking at what's here, the locations of the structure that is encroaching in the setback, I've got existing parking. I do have some landscaping along that southwestern portion of that drawing. The golf course itself, obviously, I think that they would comply with the landscape buffer standards for trees out on the course itself, but this one, the landscape buffer for me is more the tough one, whether, that's necessarily a variance there, given its distance from the property line. The need for a landscape buffer under the special exception is to buffer proposed constructions from adjoining properties. And I think that standard, looking in the code, is let's see here. Just reading from the code, along all residential zone districts and districts permitting residential use, screening in the form of standard A shall be applied along common property lines. So clearly on the golf course, we meet standard A, would be met on the course itself. I guess that's a determination, or applicant, if you could talk through if there's existed foliage that would count toward an A buffer. I don't believe you requested a variance from that condition specifically, but and if that's being the case, then the applicant would need to show they're enforced or a plan that complies with an A standard. But that A standard would be only around the portions of the property that affected by these two structures here.
Yeah, that A buffer exists today, and it is our intent to make sure it exists post-construction as well.
Okay.
So I don't have an issue with that requirement.
So with those two, pull those two variances off, it would just be the, and lot area is not an issue either, as they would be conforming, legally non-conforming to the code. So setback would be the only variance in front of this board, and the overall arching special exception for the expansion of the use.
Okay, I understand the 100-foot setback is not a variance, but it's part of a special exception approval.
It is still technically a variance, but it's a variance inside a special exception, if you will, kind of like an egg roll, if you think about it, something inside something else.
It's a little unique.
Yeah.
Do any of the board members have a question for our applicant?
Since you weren't here last time, did you have an opportunity to look and maybe watch, or did you have a life, in which case you didn't waste your time doing that, I hope? There was a lot of discussion concerning the additional noise brought on by the pickleball, and it was great concern, and Commissioner Bradford over there being the expert on pickleball, I believe, at the last meeting.
It was Mr. Ransom.
Oh, it was Mr. Ransom that was all excited about it.
And Ross.
Oh, and the chairman.
I've never seen a pickleball court in my life.
Neither have I. And I didn't know much about it, but there was a commitment that there was going to be additional sound shielding for the people, the ones that were objecting. Do you know if those meetings ever occurred?
Yes, sir. Actually, that meeting occurred yesterday afternoon with the adjacent neighbor, and I think with him not being here today, I think he is satisfied. We talked to 2 or 3 different items of concern specifically to him regarding the noise. One of the things we have committed to doing is to providing additional landscaping and wind barriers, such as to help control noise. He's also understanding that we're responsible for meeting the noise ordinance inside Metro, which we plan to do.
Okay. So you don't have a problem with that being part of the condition for any type of approval?
With regards to what?
To the changes that you've just made, or that you
To
suggested?
add additional?
Yes.
No, I do not.
Lord knows how you fit that in whatever we're doing, but thank you.
Any additional questions? Okay. I don't think we had any opposition, so there was.
There's one gentleman who'd like to speak.
Just where the other gentleman was, please.
Oh, okay. Thank you, Madam Chair and members of the board. My name is Gary Odom. My home is at 119 Dunham Springs Lane. That is exactly north of the existing tennis courts in the plan. When I built my home in 1993, those tennis courts were there. I have no problem with tennis courts or pickleball courts. I've been a member of Hillwood Club for 40 years. I had really no problem with either Plan A or Plan B that I have seen. The concern that I have, because it has been discussed in past years, is whether the special exception and variances would permit someone, and you know how organizations are, they may change their direction just with a change of leadership. But I wanted to make sure that what the application before you would not permit the club, again, which I'm a member of, to move the proposed location of the tennis center behind my house. If you have seen the existing tennis court, tennis club center, and you saw it looks like a commercial building. And these that I've seen on this plan look much better. But I still don't think that the club should have the opportunity to change its mind on where to locate that tennis center. Everything's beautiful. The only thing I have right now is occasional tennis balls that children hit over the trees, and all I have to do is pick them up, and I like to hear them laugh and scream and have fun. But I don't want a building behind my home. There's never been one there in 40 years, and I don't want one for the next 40 years. And I wanted a clarification on exactly if there's a way that we can lock in this Plan B for the location that is now being proposed, because I think that would be perfect.
Sure. Mr. Odom, I'm happy to address that from the zoning administrator's point of view. If the board approves this, it'll be this plan here before the board. And if they deviate from that plan locationally, they would have to come here and request that again. So you would receive notice of any proposed change.
Thank you. That's and I would still have the same opportunity.
Absolutely. Yes, sir.
If go to Chancery Court or...
Absolutely.
Okay. That's all I need. Thank you very much.
Thank you.
All right, well, let me ask one question. So will this plan, are you saying this plan is going to be attached to the waiver and the special exceptions?
Correct. Yes, sir. This plan will be included in our records with the board's order. I mean, I'm not speaking for them. Should they approve it, Ms. Waits will enter an order. We'll attach this plan to our records so we can see, looking back in 2023, what did the board approve? They approved this.
Thank you. That
Yes,
makes
sir.
me feel much
No problem,
better.
sir.
Thank you.
As I understand it, you're not opposed to this plan.
No, sir. I wasn't opposed to either plan. I saw them both, and I was worried about how much authority it gave, because I know my neighbors feel exactly as I do. I don't know about the pickleball and all that stuff, but none of my neighbors are going to like the idea of having a structure immediately behind their home.
Thank you.
Thank you very much.
Joey, can I just get clarification? Just for clarification purposes, because we've talked a whole bunch, and it's not on anything you, Mr. Owen. You've got 2 comfort stations that are expired, or?
Yes, sir. This board approved them, I believe.
A long time ago.
Well, in a 2019 or 18 case, and with COVID, they had to have built them within 2 years. They did not, so we lumped
So
that.
it's coming back, but it's also before us today, right?
Yes, sir. It's the exact same thing on
It's
that.
the same thing, it's just something okay.
Yes, sir.
Okay, so
And unfortunately, with one of the downsides of COVID, I wish I had and you have seen, and you probably will see more applicants come here requesting the same approval they were here in 2019 or early 2020 that they haven't executed given what's gone on the last 3 years. So.
Okay, the appellant can come back up and speak to us again.
Thank you. The plan you see is the plan that we're designing towards and have no issues with that being part of the record. And as we go through construction documents and actual permitting with Metro codes, we don't have any issues. So our intent is not to move that tennis center any closer to the neighbors. The intent is the tennis courts have been there, and as being a good neighbor to them, that's what's going back in those locations.
If you can remind us one more time, there's 4 structures in question. One is just if you can remind us again what those are.
Correct. There are 4 structures that require the setback, and that is the tennis center that you see in the lower left on your slide. It is the gatehouse off of Hickory Valley Road, and then there are 2 comfort stations out on the course that were again approved in 2018 or 2019 that were never constructed, and so we're just asking for those to be reapproved.
Okay, any further questions from the board? Okay. We'll close the public hearing then, unless you had something else. Okay. Okay. Any discussion?
I don't have any discussion. I think I appreciate that they worked with the neighbors and took their concerns into account. And so I'm happy to make a motion that we approve the request and all the special exception and the variances based off the site plan presented.
would you add also that they provide for the sound and whatever buffer over by the pickleboard area?
That's
They said they were going to do it anyway, and I know that they're going to, but make
Yeah, that's
that as a
fine.
condition.
Just a quick question about that.
Yeah.
Can we, is that a condition we can add
That's what I thought.
about the sound, or is that, I want to be mindful that we're not
sure.
teetering into.
No. They are subject to the noise, as Mr. Hooper discussed. They are subject to the noise ordinance under the Metro Code of Law. This board can place reasonable conditions on to offset special exception uses if you believe it's reasonable.
Well, yes, and yeah, no one would accuse you of anything else. My only concern would be is if there's a condition in there that would create any future issues with noise mitigation, so that if there were noise complaints but there was a buffer system in that was, I think
Gets paid the big bucks to answer that question.
I just want to avoid future headaches, but maybe I'm putting the cart before the horse here. So I'm comfortable with it conceptually, but I just don't want to create a problem that then
I don't know how to work
is a.
either, so I think that's Elizabeth's problem.
Regarding metro noise regulations, those would be applicable regardless.
Okay.
Okay. Then I'll second it as
Second.
amended.
Okay. Any discussion on the motion? Okay, seeing none, all in favor, raise your hand, say aye. Aye. And seeing none opposed, that's approved 5-0. We're going to take one short break. Oh, me.
To move through it. So at this time, however, we would like to take one case out of order just to make some healthcare accommodations, please, and that is case 2023-79. This is a request to reduce the street setback from 39 feet to 27 to construct a covered front porch for property located at 5420 Knob Road, zoned RS 7.5. I believe you all heard earlier from Councilmember Kathleen Murphy, who's in support. She's still present, and so I would like to point out that any encroachment any variance that the board grants inside of 30 feet, which the request is to go to 27 feet, is also going to require a plat amendment. So any approvals will just need to have that condition reflected on the order. This is a copy of the zoning map for this area, and you can see that the property is in a neighborhood behind McCabe Golf Course and Community Center. This is the aerial view of the neighborhood and the house in question, as well as the streetscape there. And then just a kind of a view of the neighborhood and the neighboring houses. And then here is the site plan that's being requested. At this time, is there anyone here wishing to speak in opposition to this case? I don't believe so, Madam Chair, and so at this time, anyone wishing to speak, requesting approval on this case, if you'd like to come forward at this time, you'll have 5 minutes to make your presentation.
Oh, there we go. Thank you, Ms. Waits. I'm Council Member Mendez, but today I'm not being a council member or a lawyer. I'm here as a son. This house belongs to my mom, Eleanor, who's back here, and my stepdad, Frank, and one of their neighbors, Paula, who Councilmember Murphy referred to is here in support also. Paula, raise your hand.
Before I forget, your address, please.
Oh, I'm sorry. 416 Fairfax, 37212 in Nashville.
Okay, thank you.
Councilmember Murphy really covered it. Late last year, this house was hit by a vehicle going some 30 miles an hour that just flat missed the turn in the street there, and sort of smeared across the side of the house and damaged structurally the small 4x6 front porch that's there. The damage put cracks in the walls and ceiling in every room in the house, and everything's been remediated except something has to happen with the front porch. You'll see because of the curve in the road there, the contextual overlay takes into account that house next door on the lot with a strange shape, and because that one's so far back, this house turns out to be at the very front of the contextual overlay for the neighboring houses, and the proposed 8x17 porch at one point it will infringe by less than a foot. We do know that we need the plat amendment that we'll take care of with planning afterwards. Nobody's complained about this. The sign's been up. A lot of folks have talked to my folks about it, and there's no objection, and happy to answer any questions.
Any questions from board members? Okay. And there's no opposition, so, there might be one.
Go ahead. I was just going to disclose that several years ago, I was on a committee for Councilmember Mendez's reelection, but I did not know that he was related to the applicant when I reviewed my packet until he introduced himself today. So I just wanted to disclose that. It shouldn't impact my ability to judge this case without bias, but I wanted to disclose it.
Well, while we're out, we'll just disclose that Councilmember Mendez is a friend, but it's not going to impact my ability to review this case without bias either.
Tom, you might as well.
everybody else is. I mean, he's usually on the opposite side of cases, obviously the wrong side, because my clients are always right. But and I've known Bob more years than I'm going to admit right now. You're not tricking me into that, council member.
Well, I've tried hard to go through the ordinary process, not using my Metro email, and so they just want the regular treatment. So thank you.
Nashville's such a big and small city, and it's hard not to know people in the audience. In fact, I knew the civil engineer who was here earlier and another civil engineer that's coming up later, so it's very hard not to know people. But I didn't see anyone who was...
Yeah, so about 11 years ago, I lived pretty close to this curve here. I used to walk on that route a lot as part of like the crook around McCabe Golf Course where the greenway comes out and then come out on the street. It's a pretty freaky curve, and people drive way too fast around this area. And so I am I think that the nature of the lots over here are weird because you do have a curve in the road and it's not really an intersection and they're not neatly sort of blocked out. And so, and coupled with the fact that, I mean, this is an uncovered, unenclosed porch that, frankly, I don't see an impact on any neighboring properties being an issue here. So I'm supportive.
Just to clarify, have you concluded testimony and closed public hearing yet?
Not yet. I was about to,
we're
yeah.
jumping ahead of ourselves.
Sorry.
Yeah. So I think the public hearing is closed because I didn't see any other questions for anyone, unless Tom has one. Nope. Okay.
It would just be a comment.
Okay, then we will close the public hearing and your comments.
I incorporate my prior statement.
There was no comment. It was going to remain as an open area, and since we normally don't, we always put the condition that it's not going to be an enclosed area. And she's got to reopen for us to do that, and I probably should have. Maybe we reopened so Bob can answer.
Yes.
Okay. You're not going to enclose it, are you?
Well, actually, the application is for it to be not enclosed, but covered, and so
it's fine.
Okay.
Yeah.
Then correct. Not enclosed.
Yeah,
absolutely.
Conditioned is usually the thing that's so like it's not going to be okay.
No, absolutely not.
We occasionally have those that come up where it's
and we almost always put that little in the. You just can't put it heated and cooled and what have you to make a bigger house.
Absolutely not. Totally agree.
Okay, I think we'll close the public hearing again unless there's other questions. No
Thank you.
Yeah. Okay. So is there any other discussion on the case?
Make a motion we approve.
Okay.
With the condition that it's not
be conditioned.
Imposed.
Yeah.
And the condition about the plat,
right.
which the applicant had not acknowledged. Is that
yes,
that's your motion?
Second with the condition that it not be conditioned space and that it subject to the plat amendment.
Okay, so we have a motion and a second. All in favor, say aye and raise your hand. I see 5 in favor and 0 opposed, so that is approved.
Thanks a lot. Appreciate it.
Okay, we're going to go back to the regular order on the docket. The next case was 2023-50. This is a request for a rehearing that's been filed by Ms. Charlotte Sapo, who resides at 409 32nd Avenue South. She's requesting a rehearing of an order that was approving setback variances granted by the board on June 15th for property located at 407, 411, and 415 31st Avenue South, zoned RS 7.5 and within the UZO. Per the petition that's been submitted, It's come to our attention that Ms. Seppo timely submitted a letter to our office, which was intended for the board prior to the June 15th meeting, but the letter was inadvertently not placed into the board's packet. Based on this information, we would ask the board to make a determination of whether to grant the request for a rehearing, which would be publicly noticed for a subsequent date. And we would also like to ask if you support the granting of the rehearing, whether the rehearing fee could be waived under the circumstances. Thanks.
I just wanted to make a note that per your rules, the motion to rehear is deliberated on, decided based solely upon the filings. There's no testimony. Yeah.
Okay, does anyone have comments about the rehearing?
I'm supportive of it.
Okay, is any other comments?
I'll make a motion that we approve the motion for rehearing.
And I'll second it.
And also to waive the fee, I'm sorry.
Okay,
Thank you.
so we have a motion and a second. Any other discussion? All in favor, say aye, raise your hand. 5 for, and 0 against, so that's approved. Is there a date for the rehearing yet?
I don't know, and I think the zoning administrator just had to walk out, and so I believe under the rules that has to be noticed again, but you may have more specific information on that.
No problem. We will set that for the next available public hearing. We do have to renotice as though it's a new case. It will be a de novo case, so we'll send out notices. But rather than the applicant pay that, our office will mail those out for them.
So the date on it would be, it'll be on the 20th then to do
I believe that's
mailed notices?
I believe that's our current cycle is the August 20th. I'll double check, get that, but we'll put it on the first available weekend.
Yeah, and we'll
get them back
give direct notice to
as
the
quickly as we
applicant.
can.
I mean, excuse me, the petitioner. I know the initial applicant is here. Okay. All right, the next case is 2023-67. This is a request to reduce the street setback from 74 feet to 70 feet for a home addition to a residence located at 8118 Cloverland Drive in R20 zoning district. This is the zoning map of this area, and then the aerial view. This is the home as it exists today. And the streetscape, there is a curve as you continue down this block. And then here we have the site plan that's been submitted, and then as well as some drawings. This is going to be the proposed floor plan. And let's see, the applicants are present, I gather. Hi. And then I know Councilman Swope is here. And is anyone else here wishing to speak against approval of this case? I don't believe so. And so you all, you'll have 5 minutes to make your presentation. And of course, you're welcome to add any further comments as you wish. And so if you all would like to come forward at this time.
Yeah, sit. Do you mind if I start? Hi. Thank you all for your service. Councilman Robert Swope, District 4. And as this is probably the last time I will ever see any of you again in this particular room, again, I want to thank you all for your service, especially you, Tom. You've been here forever, I think. The Jerkins here are not only asking for a slight variance for an addition onto their home, but they happen to be my neighbors. I literally live 5 doors away from here. I can look out my front porch and see their house. We live in a dead-end neighborhood. Every lot is an acre or more. This is on a slight curve. Everybody walks their dogs in the neighborhood. We don't have a traffic problem. We don't have a neighbor problem. No one in the neighborhood has any problems with this addition whatsoever. I don't think it changes the contextual nature of the neighborhood in any shape, form, or fashion. And I would ask for your approval so that my new neighbors can actually finish their additions and become my neighbors. Thank you.
Thank you, Councilman. Go ahead, introduce yourself and your address, please.
Thank you so much for your business to come before you. My name's Amanda Jerkins. This is my husband, Stephen, and we currently live at 5013 Wilkerson Drive, just about 7 or 8 minutes north of this property that we bought earlier this year. We're longtime Nashvillians, and we happily bought a house in our dream neighborhood. And our goal from the beginning has been to modify the home to fit our family of 5 while maintaining the aesthetic of the neighborhood. We, like Councilman Swope said, we're seeking approval to extend the front of the home 4 feet beyond the setback. Our hardship as we see it is that we have a gradually sloping backyard, and so we're trying to maintain as much of the flat part of the yard as possible. Pushing towards the front would allow us to keep the flat area of the yard available for our children and just our family. We will not be adding an additional story to the home. Again, it is our concern to keep within the aesthetic of the neighborhood. Our adjacent neighbors and, as you see, our councilmen are in support of our plan. The third and fourth houses down from us are less than 25 feet from the road. They're on our street, but they're not technically a part of the neighborhood. It's kind of a strange situation, but to a passerby that's coming down the street, you would see that these houses are actually about 25 feet or less from the road. So because of this, we feel like going 4 feet over that setback is not going to be completely out of character with our street. Do you guys have any questions?
Yeah, you mentioned the sort of topography of the lot. Can you just give a little bit more on the sort of nature of sort of the slopes and how that kind of forms the way the lot's shaped and set up?
Yeah, it's a beautiful backyard. It's really lovely. There is a section closer to the house that is more flat than the rest of it, and it just gently slopes back. And so we are already going to push back, as you can see, for the proposed plan. So that is happening, but we are just wanting to, keep it from going any farther back.
Thank you.
Do we have a pin for this? And I'm sorry, my computer, I didn't bring it with me today. The top of it was the top of that you went through when you were presenting.
Oh, no, I should have done that. But, yeah, it's...
I have it on my computer if I can show it.
Thank you. What I can do is add that to the slide presentation so that's part of the record.
It's in the packet.
And I have copies here if that's helpful.
There it is.
This one?
There we go.
Yeah, I just don't have the one that's from the GIS that shows kind of the actual slope. And it's hard to see, from the photos, basically just because there's not enough of the kind of lot behind it to show from the angle that I was at.
If I may, Commissioner Lawless, this has actually 2 slopes to it. It slopes like I'm west to east, which is what you're looking at right there in that picture. It's higher towards the right side of the picture than it is in the left. It also slopes from right there where you're standing downward the whole way to the back of the lot, with the house being pretty much the main level spot on this lot. Everything behind everything on this street goes into somewhat of a ravine that's all wooded that actually separates this from the next subdivision north of it, if that helps at all. Good old-fashioned Tennessee rolling hills.
Okay, any other questions for the applicant? Okay, I didn't see any opposition, so we'll close the public hearing. Any discussion?
No, I mean, I think there's a hardship that's been demonstrated. I mean, I think that the nature and the sloping of the lot here, I mean, it looks, just from looking at the maps and the images, I mean, this is a hilly area with a lot of movement on either side. So there's been no testimony indicating any injury to neighboring properties there's been good testimony on the hardship of the nature of the lot. So, I mean, I'll make a motion that we approve the variance as requested.
There's a motion, a second. Any discussion? All in favor, say aye, raise your hand. Aye. And all opposed. So that that is 3-2, no decision today, and it will remain on the docket for next hearing.
Okay. And I remembered that I did have a slide of the parcel across the street, which is what this is. It's easier to see. So could I ask for everyone to do another vote count so that I can make a note of that really quickly?
In favor.
So in favor,
The motion to approve. the
Okay,
variance.
thank you.
three of us, and then there's 2 opposed.
Okay. All right, so what that means is that this case will be back on the next agenda. The next agenda is going to be August 3rd, same time, same location, so here at 1 o'clock on Thursday, August 3rd, because we have 2 board members who were not available today. I'll send them a clip of this hearing so that they'll have an opportunity to review the record on everything, and then they'll have an opportunity to make a vote one way or the other whenever we come back next time. All right?
Thank you very much.
Right. I want to just do a quick confirmation that no one's here on 914 South Side anymore, I presume. All right, that one's been removed from our docket today. Just wanted to do a quick confirmation on that. Then we've got case 2023-77, which is...
Is it 73 that there was
Do
a
I have the
request?
wrong number on my slide?
It was the request to defer.
I did, thank you. I think that one's not, I had hidden my slides on that since we're not doing a public hearing, but for case 2023-73, which was for the property at 3509 Charlotte Avenue. I'll do a quick explanation for why we were initially asking for a deferral, and then you all have also heard some other information regarding a deferral, and I think that you all were going to make a determination about what date to defer it to. So this is a request for a special exception to eliminate the 15-foot street setback and to reduce the rear setback from 20 feet to 10 feet for property located at 3509 Charlotte Avenue, zoned CS. The planning department reviews the application for compliance with the Nashville Next policies, and they approve the rear setback as requested and the street setback reduction down to 2.5 feet. Based on the site distance and visibility requirements, when NDOT conducted their review, they have not yet approved the plan as proposed. So at this time, the applicant and NDOT, we're going to do further discussions regarding the site plan and visibility aspects of this project. And then I think so before you would be whether you wanted to defer it for one meeting or more meetings. Certainly we're asking for some sort of deferral because the applicants are not in a position wanting to move forward today, although I don't think the applicants were heard yet as to the deferral, as I recall,
Yeah.
and so perhaps we could...
I would like, because I know Councilmember Murphy had asked for a certain time, and I'd want to give the applicant an opportunity to discuss the timing.
Absolutely. So if you'd like to just come forward up here, that'd be fine.
I think there it is. Good afternoon, John Rankin, 1709 Woodland Street here in Nashville. I would like to explain just quickly our side and then propose a compromise somewhere between the things we've heard today. We received, and I want to address first the process we've gone through. We received an email from Board of Zoning Appeals saying all other requirements other than receiving the sign-in sheet from the community meeting have been met. So whatever, and we were confirmed that we have met all the requirements for this meeting by the BZA staff prior to this meeting, except giving the sign-in sheets, which we gave yesterday. So if that had not been the case, we would have done something differently, if I could put it that way. Secondly, the community meeting requirement for this type of special exception request, it's not a variance, it's not a rezoning, it's just a special exception, says that the appellant shall make contact with a district council person and neighbors within 1,000 feet of the subject property. And we did that several times. We mailed it out several times, in fact, total of 3 times to all of those within 1,000 feet. And while the discussion was about how we held a meeting not in the district and then another meeting in the district, that sounds to us like we went above and beyond. I know having 2 meetings instead of 1 exceeds the requirement. We did hold it at 4001 Charlotte Pike, 5 blocks from here at Common Ground. We had a good turnout. There is no one here after 3 separate mailings in opposition. In fact, most of the folks that came, if not all, had questions about what our requirements would be for trash collection and parking, et cetera. But we have no one in opposition. We have no emails or information from anyone that they oppose our project. We received notice yesterday morning that NDOT wanted a site visibility study. And so what we have discussed with Ms. Waits in that interim is that we would love a deferral so that we can provide that information. As far as Councilmember Murphy, I would have assumed if I emailed her and she had a conflict that I would have hoped she had emailed me back and say, because I sent it to her personal and her council email, I would have hoped she would have said, I cannot be there, can we do it another night? And we would have welcomed that. Our requirement is to make contact, and we always would want to do that. Failure to comply, though, if you read the statute, it says may result in a deferral of your case. So I think it would be inappropriate to deny as requested. Secondly, I also want to point out that November, I think almost every case that's come before you today, if not majority, have an incumbent council member that is no longer going to be there. And I don't see any other council members coming before you and say, wait till the next council person comes in. What it does for us is it gets it beyond our purchase date of the property, our contractual purchase date, and we lose a lot of non-refundable earnest money. And I don't think it's fair to say, okay, we're going to go out 6 months, 5 months for this special exception. It's not a variance. We're not asking for things that aren't recommended by the planning department. So my compromise, I would like to offer this as an idea for the board, and that is we would redo the process so that there's no concern about whether we followed it, and make our submittal by August 7th for the September 21st meeting. We will redo the process and immediately find a meeting place, date, and time with Councilmember Murphy to redo all of our entire process for the September 21st meeting, which would get us inside of our contractual purchase period and also give us an opportunity to provide NDOT the site distance information they would like. So our request of this board, with the explanation I gave you, understanding that I have emails from the Board of Zoning Appeals saying you've met all requirements, I would propose that we submit this by August 7th for the September 21st meeting, and immediately work with Councilwoman Murphy on the location, date, and time for the community meeting at their convenience. If you have any questions of me, I'm happy to answer.
Do you have a question? I drive by the property often, and I did notice the grass was high. I don't actively seek that out, but I did notice that it was high. I'm a little familiar with the property, and I don't remember seeing the sign either.
I have probably 25 pictures of the sign for every day.
Yeah, I'm not saying it's not there, but my question is, can you cut the grass so the sign is more visible?
We're going to ask the owner that we can cut the grass.
Okay,
But again, I've heard everything of Councilwoman Murphy. I've worked with her before. I've built 2 houses next to her house. I know her very well. I know her to be reasonable, and she's helped me with a variance before for a sidewalk at 221 38th Avenue North in front of this board. I know we can work together, and I know we can figure this out. What I'm saying is if we could just start fresh from August 7th for September 21, I'll incorporate everything I've heard into doing this process exactly as requested, including the grass, yes.
Thank you. Any other questions for that appellant?
When do you anticipate the being completed with NDOT's requirements and requests?
NDOT's requirements we could actually have by Monday. They're asking just that our request to be 2.5 feet from the property line in the front does not impede either neighbor, commercial neighbor on either side, from visibility down Charlotte. What I don't think we've presented to them correctly is that right now our property line is 10 feet from the traffic lane, and we have an 11'6" dedication. In addition to that, we're going to be almost 22 feet from a traffic lane in the end. If we presented that to them, the triangle of visibility turns into a cone of complete visibility, and we just need to present that to them. So what they've asked is, okay, show us that. It's not our access. We don't access from Charlotte. We would be accessing from the alley. And that was a request yesterday, and we could have tried to get it between then and now, but then it would have been a rushed, we want it to be really super clear.
You said you had a contractual, you got a drop dead day in your contract?
Yes.
And what is that drop?
October 15th.
October 15th. And there's no provision in your contract to purchase to extend that?
There is not. We've actually are in the extension period. But this was originally to be heard July 6th. I think Council Lady Murphy mentioned that. We actually submitted to be for the July 6th, and the planning was unable to get the recommendation in time. So we are moving into our, already into our extension period.
Okay, any further questions? If not, then we'll call Councilwoman Murphy.
Thank you, Board. To just address a few things that were said, whether this was to be heard on the previous meeting on July 6th, which is what a letter a constituent sent me said. The first community meeting, while the applicant has stated that they've scheduled 3, the first meeting that I heard about and was invited to was emailed to me on the 15th, so earlier this week, for a meeting on the 18th, which was during a council meeting. August 3rd is not an acceptable date to hear this again because it's election day, and that's literally when my I know if you weren't sure is when my the woman who will be taking my seat will be obviously busy, and I wanted her to be here for future meetings.
I think the proposal was September 21st.
Right, but I wanted to address the first one that was mentioned. In September, we technically don't have council members. While I am technically, my term ends the 31st of August, and my successor will be sworn in. She's not technically really sworn in a real councilwoman until October 1st. The lack of preparedness on the applicant side is not grounds for a variance or exception from rules, conditions, and the process that the BZA clearly lays out. Staff's error in saying that they had completed the things that the staff checks off on, again, is not reason or sufficient to say that there should be a change in this process. If NDOT had requested more time or planning had requested more time, that is reasonable to have a deferral for that, but the timeline set forth is not acceptable in the timeline of what is council and what does communication with the council member mean. If they had 2 other meetings, they were not communicated to me by the applicant, and therefore should be not even considered as if they had happened. I had read your rules in the past and was trying to pull them up. I knew that special exceptions, you had to coordinate not just let the council member know when the meeting was. And so with that, I'm going to renew my request to y'all to at least push this out where the new councilwoman will be able to hear from constituents. I've heard in favor of, yes, we want our housing to be, new housing and density to be on the corridors, but on the flip side, I've heard from residents who do not want this project here, and they are asking you for a special exception from CS zoning and the setbacks. So it's not like they're just asking for one variance here. They're asking for adaptive reuse from the CS zoning, and then they're also asking for a variance from the setbacks. This also could have, because there have been other people who've come to me having this property under contract, they came to me requesting a rezoning of this property that wouldn't have needed variances from the zoning code. And while adaptive reuse is probably not considered necessarily a but it will be, if you grant a variance or adaptive reuse of the CS, you're essentially creating a non-conforming use here where other properties on this corridor that are CS are having to seek rezonings for the residential use. I would recommend that this needs to be a rezoning and go through the proper process that way with the new council member, or deferred or denied. I'm happy to answer any questions.
I'm wondering if he can get the process started by applying on August 7th and then having a community meeting prior to leaving on August 31st, and would that be an acceptable?
I'd have to ask the new councilwoman as well, and I mean, there are going to be issues that we will have to work together as we hand that baton across kind of September into October, but I'd need to speak with her and find out her comfort level, because she'll be a new councilwoman as well.
So, and just, you stated the term ends August 31, but someone's not sworn in until October?
Basically, she'll be sworn in after the election is certified, but she's not considered the actual, so like, if there was a special called meeting in September, there's really not a council to have a special called meeting. For example, there's not like a legislative body, technically, there are no council meetings in September.
Okay.
It's kind of a gray area.
That seems like a problem, but that's outside of that.
No, I agree. No, when I realized this, I asked council staff about it, and technically some council stays on for the runoff, right? So like my colleagues who have runoffs, they will continue to be the council member through September 15th or 14th, I believe, but I am, I only had one running for my spot.
Sorry, I guess.
The public hearing's open if you have a question for the councilwoman. Okay.
You have not had any conversations in depth with your successor yet?
No, not on this. I sent her a calendar invite to come today so we could talk, and I could kind of show her how.
But she's running for office right now.
But she got a flat tire on the interstate, and so she couldn't make it.
It's been a strange day.
And I will tell you that there's been a zoning request on Charlotte also that I said, y'all don't have time to have the community meetings, and I've asked the Planning Commission to defer that until October so the new councilwoman would start that process and finish that process, so it's not abridged.
Okay, any other questions for the councilwoman? Okay, we'll close the public hearing and discuss.
No, I'm mindful of the closing date concern, and I identify precisely one meeting that's open prior to October 15th. It's the closing date after October 1 when the council member is sworn in. But so what I'm getting at is finding a way to have the public is deferring it to the October 7th meeting so that the applicant can get this approved or not before the 15th. But
the only issue I have with that is like that assumes that meeting will be clean. Like that meeting will give them a decision that won't run into the runoff.
Sure.
Like I completely understand the council member's frustration. I appreciate her being here, but I'm also sensitive, like we've talked about this before, a lot of times if the codes office gives someone information and they rely on that information, we're also normally sympathetic to that as well.
Yep.
So
100%.
I'm more inclined just to find a compromise. I do think that, I think the applicant could have done better? Yes, of course I do. Do I think that this was all sort of nefarious? I think they did, based off the information they were given, I think they made a good faith effort to comply with our rules. And so I'm inclined to, I don't know, I think a compromise that understands both sort of pain points is ideal. And normally we would just defer this for a couple meetings. And so I've never seen a deferral go out that long absent something horrendous.
Yeah, and I mean, I guess the reality is, council member gets sworn in, council member doesn't really become a council member, which still just makes absolutely no sense to me whatsoever. But that doesn't preclude the person who is the council member inaugurated but not yet council member seated to come to a meeting during September to speak on a project, and it doesn't preclude the current council member from attending the meeting. So I think are you thinking about just doing what the applicant is asking with the September deferral? Yeah, I could get behind that.
Well, my concern was, and if I might, it was, and I listened intently, it was like, okay, everybody else did something wrong. We didn't anticipate or do anything that caused all of this, and I didn't like throwing the fault the way it was thrown by the applicant. I am, however, sympathetic to a home health care center type of organization. I mean, getting older too. But I'm
well, can we ask the zoning administrator about this email about whether everything had been approved?
But they still haven't gone to NDOT at that point.
Well, that's true, but I just want to.
Until yesterday.
Well, I just want to know. I mean, in terms of
plan ahead. I mean, it's not our fault. We're getting dumped in our lap.
Well, I'll say we've been told that there was a email saying everything was gone. I just want to verify, trust but verify.
I'm not aware of that because I wrote to the applicant several days ago. This was before the 18th meeting, and notified them that we didn't have proof of a community meeting in the file, and I asked for the sign-in sheet. At that time, I was notified that they had had a meeting in late June in East Nashville, and I also asked about the feasibility of a West Nashville meeting being held deep in East Nashville, really Inglewood. Okay. Afterward, I was notified that another meeting would be held on July 18th. I was provided verification that Councilmember Murphy was invited, and I think she's absolutely correct. It was a few days prior to that meeting, and it would have been easy for the applicant to be aware that that was on the date of a council meeting. So although that wasn't communicated between the two of them, it's certainly a public date. The council meets on the first and third Tuesday of every month, except for the month that Councilmember Murphy is explaining to you, which is September of every fourth year. With respect to, so that's what I'm aware of. I think that probably there's kind of two sides to all of that stuff. At least we have one, I feel like a little bit of relief in this situation insofar as the reason for that gap with the council in September of every fourth year is because of the runoffs. Like, we don't know who the mayor is, as far as I know of, like maybe ever, right, in that month. And most of the time, council districts also are contested. And unless someone has gotten 50% plus something, then we might not know who that person is. In this case, at least, I just looked at the Davidson County ballot. There is only one person running in District 24, so we do have the benefit of, we can say who the council member is going to be. So I think, for all purpose and effect, once this council closes, which is the second meeting in August, even though technically the term runs to the 31st, so all that is absolutely correct. But basically, that council member, I feel like it's feasible for that person to start, accepting some of that communication, basically, at least after that second meeting in August, and potentially now, insofar as this case is concerned, now that we're all aware that this is something that very well may be continued. So those are just some information I wanted to add on that. Thanks.
I have to say, I like the idea of starting again with a fresh, clean slate with the applicant submitting, I guess, for an August 7th submission date, because then that starts the process clean, and the councilwoman's aware, and the new council member would also be aware. And so they're starting clean with a new sign, new notices, and I happen to like that idea.
Cut the grass.
Jump right in there.
Well, and frankly, it wouldn't, I mean, if there are substantive issues that the council member or future council members see, those would still be sussed out and be able to be addressed by us at a later date. So I'm cool with.
Procedurally, though, if we went in that direction, and I might make a motion myself in a minute here, would we have to deny his current request in order for him to start again? No?
I would suggest, for ease of everybody, us included, Elizabeth and I, let's keep the same case number. We'll just push it out. We'll sign that case number that day and run with these dockets and documents and such. And
so we would
go ahead, please.
We would defer to September 21st with the understanding that by August 7th he would do a new filing with the same number.
Procedurally, I guess would be, technically he'd withdraw the case, refile. You guys are allowing us to take the case and slot it for what we've agreed to as far as the date. It's not an issue. I mean, you could defer it. It's the same thing.
Mr. Hargis, can I ask a question?
Sure.
Because I've never seen this as a condition to our deferral, is it okay for us to say that the lawn get cut and that the signs be visible and all that other stuff?
I think they've gone on television today and can't been sworn to.
Okay.
So if not, we're happy to cite the property owner for a property standards violation. So.
Joey?
I mean, for me, honestly, I'm fine with just treat it as a deferral to that date, and we'll take it from there. We'll take it from there. Yes, sir. Okay.
Elizabeth, how are you going to write that up?
We can put in the order that the applicant has agreed that they're going to also send out notices again, so that any neighbors that would wish to be, yes.
All right. I just want to know who's governing us in September, or if it's completely lawless.
I think that is a good question. I think it's a valid question that actually we might want to explore. I don't know if you all want to do that today.
No.
I do think that I'll be keeping a close eye on applications that aren't like this one. Like if it's someone where we have a known council member, whether it's an incumbent who's getting, that's already sorted out without a runoff, or whether there's just one person running versus districts where it's unknown who that council member is. I do think that we need to be very sensitive of that.
Yeah, in the words of our UK friends, we need to mind the gap.
Yeah.
I'll make a motion to defer case number 2023-073 to September 21st meeting with a request that it be placed at the start of the docket.
Second. Yeah, and they start off and renotice, cut grass.
But, yeah, subject to all requirements of the zoning administrator.
Okay, so we have a motion, a second. All in favor, say aye and raise your hand. Aye. I don't see any opposed, so that deferral is approved 5-0. No, I didn't see anyone opposed. No. Okay, good luck.
Write these minutes.
All right. So now we're on 2023-77. This is a request for variance from the setback and height requirements to construct a 6-foot perimeter wall along Belmont and Woodmont Boulevards. This is a corner lot. I'm sure probably a lot of us are aware of this, daycare that's been there for a really long time, located at 3420 Belmont Boulevard.
Yeah, and I'll state for the record, I drive past this site routinely and have visited it, which I think I'm supposed to do.
Yeah. There's a lot of traffic at this, intersection. Obviously, it's a lovely part of town, and so I've got a picture of what the intersection looks like in here as we move through our slides. So this is the aerial view, and then I don't recall what that institution is across the street, but there is a large facility across the street, and then otherwise it's largely residential. This is the structure of the daycare center, and this is a view of the parking lot, sort of looking along, like to the left, you would have seen Woodmont, and then in the back, you would see Belmont going like horizontal. And then there's the intersection. So this view is actually more along the Belmont side. And this is the existing fence. So basically, currently, the entire parking lot is easily accessible. There's another side of the fence. So those are currently on either side of the structure, and then the parking lot would be accessible to anyone, as well as the entrance to the facility. They have a lockdown entrance, but to get physically to the entrance, it's there just adjacent to the parking lot. This is the site plan that they have submitted. So who is here to speak in favor of this request today? You're going to be presenting this, and then is anyone here wishing to speak against this request? Okay, and I say against. I just want to clarify that some members of the public let us know they just wanted to speak to you all, so maybe not just necessarily against, but they do want to be heard. So we've got a couple of folks that we're going to hear, and then we're going to give each side 10 minutes. You can reserve some of your time, or if you have some time left over, then we'll just hold that back for you so that you can respond to anything that you might hear from the other members of the public today. And so with that, if you would just come forward, state your name and address, or if you're on behalf of the daycare facility, and get started with your presentation.
Can you hit your mic?
My name is David McCracken. I'm the Executive Director of Green Hills Child Development. My family first moved here, and it was my personal address in 1976 when my mom couldn't find childcare for my brother and me. That wasn't very upsetting. And she started 3 classrooms. We've been there for decades, serving families of young children. My personal address is in Williamson County. I live at 2204 Clare Park Drive. So the request, and you can't quite see it from the very top edge on the right of the graphic there, but there would, under what we propose to do, there would be a new outlet for ingress and egress from the property. The need is really 2 aspects. Councilman Pulley, his focus was on the security, and related closely to that is the safety in the parking lot. And I would actually begin with that. Because we're on the corner of such a busy intersection, folks will want to rush through our parking lot to go to a utility entrance that's on the Woodmont side, and it can be very dangerous. Folks aren't patient enough to wait for the left turn arrow, and then when they get there and find that it's a gate and they can't go that way, they go even faster out than they came in. And we've had some near misses. We're thankful that the Lord has blessed us for not having any injuries, but that's been its own concern for a long time. So to solve that, and the security concerns related to people who are not invited, people who have nefarious intent, who might do damage to property or other property damage, or even worse, we need to be able to keep them at a distance. And so the way that this perimeter fence, it would be a wall and a fence combination that would allow us to allow families that have, and employees that have an access code to come onto the property in their vehicle and allow to hold off anyone else until we can understand who they are and what their business would be. Same thing with pedestrian traffic. There would be a man gate at one location close to the intersection. Many of our families live close to us, and they would, they'll come on their bikes or they'll come with a stroller and to bring their children to the beginning of the day at childcare, and we want them to be able to do that comfortably in their usual mode of transportation without having to come in through the same way that the cars would be coming. But by being able to have it not only fenced, but at the new outlet for ingress and egress, to have it gated, would allow us to control that better, which we think is really important to the safety, not only of the children in the parking lot as they come and go, but for security purposes as well in the age we live in. That's the short version. I appreciate any opportunity to answer questions, clarifications.
Wanted to ask about the solidness of the fence.
Yes, ma'am. I remember your question. Thank you. So my understanding from the zoning examiner who we met with is that a 6-foot height would need to have a 10-foot setback. We would want to build it up at where the property and the right-of-way join. This would be a 6-foot fence. A 6-foot wall, and at various intervals it would drop down to 2 feet, and we would have a wrought iron, probably aluminum though, but a wrought iron appearing section to help us be able to observe who's walking by and to allow still some observation of the property. It matters to us that it would be an appealing construction and design. That matters to us. Our family has been there for decades, and we want to be good neighbors. And so we would take that as a responsibility to make sure we do this in a way that adds to the neighborhood, if not at least maintain the aesthetic.
And I think I saw it in your packet there. It's set back a little bit more at the corner from a visibility standpoint, right?
Yes, sir.
Safety of traffic. Okay.
Yes, sir. And my understanding is that there's a zone of exclusion where we would not be able to build there, and it wasn't our intention anyway, because having that corner, the visibility for safety makes a lot of sense. My late father he used to keep the hedge trimmed back, and when we realized that that's something we hadn't been doing, we took steps to get that cut back to where it should be. So there's 35 feet from the corner of the property going in each direction along the road, and then connecting that. From what I understand, that's a zone of exclusion where nothing more than 30 inches could be built. We don't want any part of the fence to be in that area. We would want it to basically have that angle at the corner to allow for that safety visibility. I turn left there going home each day.
Any other questions for the appellant? Okay, I guess we'll take the opposition now.
Yeah, if I can reserve my time, that would be great. Thank you so much.
You can.
I'm Steve Grindon. I live at 1504 Woodmont Boulevard, 5 properties east of the applicant. Thank you very much, board, for this opportunity to speak. I had some questions as a neighbor. I don't know specifically where the applicant intends to put their privacy fence. I'm all for security, particularly when it comes to children. I'm a father of 3 myself, and I certainly hope they can build their fence. I don't know why they need to do it on the setback. I guess I haven't heard a compelling reason for that. May I ask the applicant that question, or may I ask you guys that, or?
He'll come back up after and provide a rebuttal, so we can ask him to answer your question at that time.
From a protocol standpoint, ma'am, I don't think I get to further questions, though, do I?
You do not.
Okay.
But he will. We will ask him to answer. And it was in our packet that what would happen if he put the fence in its location where it's required by the zoning code is he would lose parking that's required for operation of the daycare.
Okay.
But we will also ask him to verify that.
As I say, I live there. I think that there are probably 11 parking spots in question. And as I walk by there, I've taken photographs of them. It's pretty deep. So I don't know that a fence on his property, the way every other property owner would have to build it, would impact that. I would also ask if the applicant has considered other options. For example, I have photographs, but it might be better if we went to other slides. May I ask? So there was a slide with gravel right there. That's an approximately 50 by 75 foot area of their land that they could access parking if they decided to grade it and have somebody build parking spots there. Can you show the one at the community center across the street? May I? That's that one. So there's a brand new community center across the street. I don't know if the applicant has reached out to them and said, hey, can we lease some of your spots for our staff? Right there at the corner is big stoplights with sidewalks, you know, the metal ones. Thank you. If the applicant decides to build their fence on the other side of their current hedge on Woodmont Boulevard, it would be very hard for people to walk their dogs in the morning or the afternoon just because it's right by the side of the road, as you see in that photograph I've supplied. If they require a car pass code to get into their facility, I think that's great, even though it would back up traffic even more on Belmont Boulevard, which would be, if you've driven by it, it's ridiculous as it is, but I get it. If they want to limit access to their building, that's totally cool. I just think that there's spaces for them to build this fence on their property.
Hi, my name is Cynthia Laws. I reside at 1502 Woodmont Boulevard, Nashville, Tennessee, which is approximately 6 properties east of the applicant. I am an avid walker along Woodmont Boulevard, which does not have sidewalks, and my concern is that this wall that's wanting to be erected onto state property would then impede my ability to continue to walk there. I was wondering if the applicant could actually move the wall over to their side of the property. There are either in between the hedges that are there along that route or before those hedges, because there's space there in order to be able to, it appears to me that there's space there in order to be able to put that wall, because yeah, there are parking spaces there, but they don't go all, there's this huge amount of space in between their parking spaces and the hedges that are there, that they could actually put their wall there and still not impede the parking in that area. And then on Belmont, as has been discussed, there is an area there that is like, it doesn't seem to be used. One time it seemed to have just been holding brush, and I think the brush has now been picked up, and there's some potential there for the applicant to use that property, which is their property, to do what they would like to do without impeding the center. Thank you.
When the applicant sent the letter out to the homeowners, I took the opportunity to send him an email, and I asked a question which he didn't answer. I said, how much of the setback do you want to take? Because it seems to me, I would sure like to know that. If he says, look, I'm going to take 8 feet of the 10 feet, I'd say, okay, great. We can walk along that boulevard, and as Cynthia said, because Nashville is not committed to sidewalks, that would still leave some room for safety for pedestrians. But if he says, look, here's the schematic, we intend to take 70% of the setback, I'd say, gee, please look at the photograph I just gave to the board to look at to see that there's not a lot of room there.
Can I ask a question of the zoning administrator? This plan is not proposed building it in the right-of-way, correct?
We could not authorize permission in a right-of-way.
So he's proposing to build the fence at his property line without a setback, but it would still be on his property line. He cannot build in the right-of-way.
May I ask what the difference between a setback and a right-of-way is, please?
A setback, the right-of-way is where your property line starts, the portion which the city owns for the road itself and utilities. So that's the edge of the right-of-way is also the beginning of your property line. And then for fences, we have a setback for solid fences from that point back 10 more feet.
Okay, so, forgive me. Is that Woodmont or Belmont, though? Doesn't say.
Well, that's the side, that's Woodmont. So Belmont has a big section that's still
Okay.
public right-of-way that's outside of their property, a smaller section.
So how, I'm sorry, sir, may I address
Yes,
this to you?
absolutely,
So you said the right-of-way is at the edge of the asphalt?
No, sir. No, sir, not at all. The city owns, in typical roads, is a 50-foot width, and within that is the actual pavement. And then there's also grass.
Okay.
So at some point, the city takes over and the private property begins.
Yes.
So it's a misnomer. Sometimes we measure from pavement. We do not measure from pavement. If there are utility lines or utility poles out on this side, that's a pretty good indication the edge of what the city owns. And then from that point, 10 more feet back
is the setback.
Is what's required for fences.
Okay, so if you have a chance to look at the photograph I gave you about the edge of the property where the city utility pole is, that's about 3 feet from the road. And again, as Nashville doesn't have sidewalks, that's not very safe for people who intend to walk.
One thing that might be helpful is what I was seeing in their plan is they plan to propose to build the fence right at the edge of where the parking spaces are. So it wouldn't be taking much more of what might be a grassy area between the pavement and their parking spots.
May I ask you to ask the applicant a question when his turn comes back?
You can ask us questions and we'll decide if we can ask him that.
So if, I don't want to paraphrase you, but you said the applicant intends to build a fence right on the existing parking spots?
Right at the edge of the existing parking spots, which is how I'm interpreting something that was shown earlier.
Would that make it the fence on the north side of their existing hedge?
I think the best, answer to these questions is that site plan. Outside of that, then the applicant, can perhaps provide a better explanation for you.
Okay, but I don't, in this site plan, I really don't see distances marked.
When the applicant comes back up, we're going to ask him a bunch of questions.
Perfect.
Okay.
Can we go back to picture number 2, I believe? The next one,
This way?
the opposite way.
Oh, okay. That?
Yes. So is this the parking lot area facing, that's by
along Woodmont.
Along Woodmont.
That's along Woodmont. That's Belmont.
Okay.
That's on the Woodmont side.
Yes.
That's on the Belmont side.
Okay. All right. And is the fence going to be along the Woodmont side? Okay.
That's, yeah.
Okay.
We're going to have the applicant come back up. Do you have any further questions?
Just that if they were going to do it on the Woodmont side, maybe they could put the fence on their side where the hedges are that he was talking about, he cut back. So just totally remove those hedges and put his fence right in smack dab in the middle of where the hedges would have been. And then there would be no need for a setback at that time.
Okay, we're going to call the applicant back up.
Thank you.
Thank you for your
ask him some
consideration.
questions.
And I think
just
it's
really
that
quick.
picture, yep.
Yeah, just really quick. Unfortunately, I didn't capture it, but if you were standing where I was standing when I took this picture to the immediate left along Woodmont, there are hedges right there, and I think that's the hedges that they're talking about. And the hedges pretty much provide, a slight barrier along the entire side, along the Woodmont side. That's not the case with the Belmont side, where the turn-in entrance is to the front of the property in the parking lot.
So that would be where those two cones are at the far end. The hedge is right next to the
Yes, and all the way up, like closer to where I would be standing the whole way.
As I understand it, the fence, though, is going to encircle the property, correct?
We'll have the applicant come back up and answer all our questions. And if we can put the slide on of the site plan. Thank you.
Okay. And sorry, it's, unfortunately, you cannot see that cutout for the visibility triangle, but I see it whenever I'm looking at the piece of paper.
Okay, you heard a lot of questions.
I did, and I'll do my best. Thank you, neighbors, for the opportunity to clarify. I'm sorry I missed your point of clarification. So my understanding, as discussed, the setback would be 10 feet from where our property meets the right-of-way. And as I understand it from our surveyor, that is about a third of the way into that hedge line from the parking lot side. And so this would not be on the far side or the street side of the hedge at all. That would be in the right-of-way and would not be permitted. This would be where, really just inside of where the property meets the right-of-way on the parking lots, our parking lot side. So that hedge would almost entirely go away unless there were parts to leave for, aesthetic reasons. But I'm sensitive to the fact that there's not much room there because I used to mow the grass there from a young age, and I know how the traffic can get. We're concerned for our neighbors to have a safe place to walk, and so don't want to get in the way of that. The one other question I recall was where the photograph of the gravel is. That is where the new ingress egress would be, and so we can't create parking there. And just to be really clear, we don't want to increase our parking capacity. We just want to preserve the capacity that we have while securing the property from anyone with bad intent, who I obviously don't count our neighbors among. They're just wanting to go for a walk. But we've had some property crimes and a couple other close calls with possible violence that are a concern to us because it could get worse rather than better. But yes, does that clarify?
Well, I had a question about on the top of the slide here, and it's cut off a little bit, so we don't see the road that's to the plan north. Is that the new ingress egress?
Yes, ma'am.
And that's
what we
off
proposed.
of Belmont or Woodmont?
That's off of Belmont. Yes, ma'am.
Okay. So there is a little bit of space if cars need to double up and they can pull in. There might be a space maybe for 2 cars.
Yes, so there would be room to an outbound lane, inbound lane. Codes made it clear that we would have to follow the rules for queuing. Right now, we don't have any blockage to keep anyone from coming in as far as the fence goes, and so the only time that we have any queuing that reaches out into the road is really exceptional. This arrangement would allow plenty of queuing. There's a 40-foot requirement, and this would meet that or exceed it. And so inbound and outbound lanes instead of the horseshoe shape configuration we have today.
Had you spoken to your neighbors across the street at the community center, just in general?
So they were included in the notification. That's the Community Foundation of Middle Tennessee. Their new headquarters is across the street. It didn't occur to me to ask them to let us lease their property for parking. We have neighbors that often ask us to do that, and we like to accommodate that when we can, but I would assume...
I was just wondering if if they knew of the project.
Only the standard notices that went out and the sign that's up. We sent a courtesy letter further explaining what we're after.
Okay. Any other questions for the applicant?
I know that the applicant answered this question, but I just want it to be clear. So one of your neighbors asked the question about the hedges, and I think the response was, as I understand it, the hedges don't really impact the design of what you guys are trying to do. Is that fair?
Except that we would need to take it out of the way. So from the street side, from the Woodmont side, there's a big hedge, pretty big. Most of that would go away to create more room along the, between the new fence and the street than there is now. So it would actually expand the space that neighbors have to walk through because that hedge would come down. It's on the property that we have and on the public right-of-way.
Okay.
Does that clarify?
Yes, it does. Thank you.
Any additional questions?
No, I'm not gonna go down my tree route today. I'll leave it alone.
Okay. If there's no additional questions, we're going to close the public hearing and discuss.
Thank you again for the opportunity to be here today and for the neighbors for
extra questions.
Well, I saw the hardship in the fact that they would be losing parking if the fence was moved in. I mean,
Is that self-imposed, though? I'm just asking.
Well, no, because the parking is required, and I mean, so I don't think so.
I mean, but it is in the sense that, like, you don't, like, this is an addition. Like, listen, don't hear what I'm not saying. I understand the reason for why they want this, and I'm very sensitive to that. All I'm saying is, like, they don't have to build this fence this way, so this was a choice, and so if you lose parking, you know that parking is required anyway because of the type of business you run. So to say that, I don't personally think that's the hardship. That's for the record. Like, you made a choice to build a fence this way on the property line when you run a business that requires parking, so.
But the amount of traffic,
That would be more of that sort of.
you knew I was going there.
I agree with that. As
Yeah,
hardship.
I
And
mean-
the security concerns, I think those
Well,
are.
the security, I mean, security is a huge concern, especially since you've got a lot of.
Well, I think the location at a major intersection also is
And the type of
impacts.
business
Yeah.
It's been there for 40 or 50 years. Basically, it's changed a ton. Have you
I
tried
guess
to?
my only question is anyone concerned? It's just me. So, like, I want to vote for this. So my only question is, like, as someone that lives in a neighborhood where someone has a fence on the property line that's opaque and you can't see to make a left or right-hand turn, and there's been a few near accidents because of it being on a corner. And because of how busy this intersection is anyone concerned about, like, visibility? Or, I know that we did the cone, and I saw that in the packet, and is everybody comfortable with that? Because if they are, then, I mean,
So
I just want to ask.
I live near the intersection of Belmont and Battlefield Drive, which is two blocks from this location. I drive through this intersection almost every day. My mom lives off Belmont Park Terrace, so this is a frequent sort of. I'm a commuter of this intersection all the time. Well, no, I'm actually. Well, what I'm saying is that the intersection. I've made every possible turn off every possible direction here. I am comfortable, and that was the reason. My primary question to the applicant had to do with the visibility at that corner from the way that the property is situated. A left turn is not going to present an issue. A right turn onto Belmont off of Woodmont isn't going to present an issue because of the way that fence is going to be situated. Just if they were at any other corner here, I think it would be a bigger concern. But because of where they are at the intersection, I don't have that worry. Personally, I mean, it's just because I'm like. It's one of those. If it was on another corner where it would potentially obstruct, but
Does NDOT have to bless this? And I don't know which one of my wonderful cohorts over this way I need to address that to. I mean, has NDOT got to do anything with this?
Yes.
Okay.
Yes, NDOT. Okay. So if you'll grant me 10 seconds of soapbox. In this next council, the zoning administrator in our codes department is going to ask the city council to please require building permits for fences. We go through this constantly. You've seen these appeals that come here, and we don't require permits. So yes, NDOT always has say over fences near a public right-of-way. But yes.
So with that, I make a motion that we approve the request as presented because of the hardship presented regarding the safety and the location of the intersection and the type of business that's run here.
I'll second.
We have a motion and a second. All in favor say aye. Aye. And none are opposed, so that is approved 5-0. And we'll take a short break.
yeah.
Gonna make sure we have it just a second. And Channel 3 is ready to get our video started again. So our next case is 2023-80. This is a request for a special exception to operate a restricted Class 2 daycare with a maximum of 35 students for a corner lot at 1501 Straightway Avenue within the R6 zoning district. So the initial application requested 53 students, which would have been a Class 3 daycare. And based on feedback that we got from NDOT, which I'll explain further here momentarily, the application's been amended to request up to 35 students, and I've provided that information on your desk. Verification that we're going to reduce the building permit application to 35 students from 53, and then the feedback that we got from NDOT. So special exception request, so the planning department recommended approval based on the land use policies in place for this location, and NDOT recommended approval on the condition, approval of 35 students, on the condition that an ingress and egress plan be demonstrating that the daycare operations will not negatively impact the surrounding neighborhood and abutting intersection, must be approved by NDOT prior to issuance of the permit. So that's how we arrived at a.
Okay, so
Yes?
this email is not so much that they oppose it, is that they are okay so long as they meet the condition of an approved circulation plan?
They are okay with it as long as they have an opportunity to actually review that plan before the building permit gets issued. But in terms of zoning, they're okay with it, and then they're also going to do a site plan review prior to the permit issuance.
Okay.
So with that, here is your zoning map, and here is your aerial photo. This is the church, St. James AME Church, that sits at this location. And here's a view from, the corner. It's a corner, so it's kind of the whole lot there. And then this is across the street, which I just thought was nice to capture because that looks like a nice place to play if you're a child. And here we have the site plan. So let me ask if anyone's here wishing to speak against this request. I do not see anyone. So we have several members of our church here, that's my understanding, or perhaps from the daycare facility as well. And so you all have 5 minutes together, and perhaps maybe were you going to make the presentation? Okay. Looks like we maybe have 2 people that are going to speak in support of this today. And again, I don't think anyone's here opposing this. So thank you so much. If you would please just state your name and your address.
Good afternoon. My name is Chantrell Johnson. My address is 4841 Myra Drive, Hermitage, Tennessee, 37076. I am currently service the role as the director of Daniel Payne Christian Child Care Center, which is presently located inside of Payne Chapel AME Church. And we have the AME Church has given us the opportunity to move the daycare out of Payne Chapel into St. James AME Church. The daycare has been operating for over 30 years, and it's a huge need for childcare. The demand outweighs the supply. I think it's just a perfect location. It's directly across the street from East Park, and we're just asking to be able to utilize this property that has been vacant for a while for our daycare facility and to be a good neighbor in the community.
Were you going to speak as well?
Yes, thank you. My name is James Floyd. I reside at 909B Winston Place in Nashville. I'm a member of Payne Chapel AME Church, where I serve as a steward. I'm also a member of the board of directors of Daniel Payne Outreach Ministries, which runs the daycare that Ms. Johnson referred to. And I'll be brief here because I just really wanted to emphasize the purpose and goal of our daycare is to provide care opportunities to those who are on the lower spectrum of the socioeconomic setting here in Nashville. This opportunity to move into this new facility that we hope to develop will expand our ability to provide that service to the community, and we very much appreciate your support in that endeavor. Thank you.
And I don't recall in our packet if we saw that you had a community meeting.
Well, we sent out a letter. No one came.
Okay, so you had a meeting that was intended to be a meeting, but no one came. Okay. And there's some conditions on the screen here. We just want to make sure you meet all those conditions.
Yes, and so we have verified that the lot is a 1 acre lot. The street standard is supposed to be on a collector street. However, there's a caveat in the zoning code that can be waived for preferred locations, which this facility does meet, as you can see listed there. And I put a red star next to it because with the favorable approval of NDOT, they're able to go ahead and utilize this facility as a daycare provided with their approval. So we have that in the packet. They do meet the landscape buffer yard requirement as well. And the only thing that I wasn't able to verify from the visit, I wasn't aware whether or not there's an outdoor play area on the location. So if you could please just speak to that. Of course, we do understand that it is directly across the street from a public park. So is there a playground area on the site?
There's currently not, but there is plans to have one that will be behind.
Okay, so there's not one now, and so we just wanted to make sure that you're aware. If you ever construct one, then it's supposed to be fenced in, completely fenced and attached to the building. And so I think that that is verification of the questions that we had. Thank you.
Okay, any questions from the board members? Okay, I don't see any, so we'll close the public hearing and we'll discuss.
Oh, I'm sorry.
Oh, go ahead.
Is there a crosswalk over to Eastland Park from this?
No.
Okay. Cool.
No, I just live in the neighborhood. That's the only reason I know.
Yeah, it's a four-way stop. Isn't that correct? Okay, it's a four-way stop, and then there's a sidewalk on. You can see the sidewalk goes along. I'm not sure what that side street is. Not straightway, but that sidewalk cut out right there, that curb cut that you see to the right, that's the entrance to the park. But I can see that there's not a crosswalk, like a painted crosswalk from connecting both sides of that sidewalk.
No, it's not busy. No one drives. I mean, when I drive down there, people respect the four-way stop. A lot of people walk on that street, so you can't speed on that street because it's sort of narrow.
Well, you wouldn't speed anyway.
I wouldn't, but I'm just saying you can't anyway because it's so narrow and so many people walk on that street that it's.
Yeah, I mean, the reason I asked the question is that NDOT should put a crosswalk there, not for any other reason other than to wink, wink, nudge that NDOT should build a crosswalk so that the kids can play. I mean, I'm comfortable with the condition required by NDOT. Frankly, I wish they would care as much about making it safe for kids to walk to a park as they do about the collector street plans, but that's just me editorializing.
Any other questions for the applicant?
Out of order, Madam Chairman.
Sorry, y'all.
No, I was trying to stop you from any other questions. Then we will close the public hearing. Go ahead.
Yeah, I think I appreciate the need. I believe that they've met the requirements of the code, subject to the condition that they submit a circulation plan for pickup and drop off to illustrate impact on the surrounding traffic.
Was that a motion?
I move that I don't think it was, but I make a motion that we approve the special exceptions based upon the applicant's satisfaction of the provisions of the code, with the condition that in order to satisfy the collector street waiver in the code, that the applicant submit a circulation plan for pickup and drop off for approval by a traffic engineer.
A second.
There's a motion and a second. Any discussion? All in favor, say aye. Raise your hand. There's 5 approvals, 0 opposed, so that passes.
I was kind of impressed.
This is our last case. And I have a copy of this site plan, and I'll just pass that out really quickly when Mr. Sloan, who I believe is going to be speaking, or whoever's speaking on behalf of the applicant. On this one, do you need just a second? Okay.
1 second. You can go ahead and get started.
All right, thanks. So, this is a very large lot, as you probably saw in the planning department recommendation. It's like over 300 acre site. So this is actually just one of the addresses, of the multiple addresses. So it's this area here. It's not far from, I think it's called the Fontanelle, that area of Whites Creek. So it looked like a farm to me when I was there. I saw horses. And then that's a property across the street. I just wanted you to be aware that there's some residences across the street from the property as well. And then this is verification of the collector street. So that's one of the issues too. So I just wanted to let you know that it meets that requirement. Here is the site plan that I'm about to give you on paper too. We can come back to it. A little bit of an enlarged view, and then here's our requirements. So it meets the acreage, and then the other requirements are basically, kind of site specific. And so certainly we can hear more about that. I don't know that they're the kinds of things that would be preconditions. I think that they are sort of use conditions if approved, if that makes sense in this case, because you can see like they're instructed. They have a certain setback. They have landscape buffer yard that would need to be implemented and so forth. So I'll go back to this plan. And is anyone here to speak against this case? Okay, everyone's here asking for approval, and so you guys have 5 minutes, as you know, and if you'd like to come forward and tell us who you are, and I will pass this paperwork out.
Thank you.
Yeah.
Let me sit down over here.
Whatever.
Doug Sloan, 6354 Torrington Road, Nashville. That pretty well covers most of this. There are 5 things that you have to have in place, or 5 criteria, I should say, that this is evaluated by for a special exception. The first one is 25 acres minimum. As Elizabeth pointed out, we have over 300 acres, so check on that one. It has to be on a collector. Knight Road is a collector, so another check for that. We have to have a 100-foot buffer from any structure along the boundary with a residentially zoned piece of property. Where we plan to put both the maintenance facilities and will probably be the clubhouse are back towards the rear of the property, which was also pointed out that shares a boundary with Fontanelle. Now, there are residential properties, I think that's to the south, but we're not going to be anywhere near 100 feet of that, and certainly that'll be evaluated in more detail when we come in for building permits. Or 2 other things, there has to be a type A buffer all the way around the site, which we fully intend to do. And I think maybe not this site plan, but on other site plans we've submitted, we've shown that we've identified that buffer that we have to have. And then the last thing is, if we host a professional golf tournament, then we have to do a traffic impact study. We have 0 intention of hosting a professional golf tournament. This is a private club for the exclusive use to play golf. It's not a country club. It's just a golf course in Whites Creek. We've had community meetings. It's been well received both by the council member and the community. They even say our neighbors are excited about the idea. And the fact that we're here talking to you about something in Whites Creek and there's not a group of people behind me in different colored shirts should tell you that we've done our homework. Yes.
Can I ask you a question? I'm sorry. I just wanted to ask you, were you Were you saying that it's not a country club, or?
It's not.
It's not?
It's a private golf club.
Yeah.
My understanding from the application, from the letter, I just wanted to make sure we're on the same page about
Right.
what
It is a club, but all right.
Here, let me, and this was what I was looking at here. It was going to be stuff like that. I don't know. That was to you from, but it was part of the application.
Okay. My apologies. I thought we were just seeking the golf course, but we're also seeking a country club. Well, we still exceed the 50 acres. Again, we have over 300. The setback is the same, and so is the buffer that has to go around it. And it's also I think, permitted with conditional use.
Yeah, I think it's the same too.
Yeah.
I just wanted, you know what I mean?
No, I appreciate that very much. Yes. The great thing is that we qualify for both.
I just want to say something in an abundance of caution. We all know, most of us know Mr. Sloan, but today I have the opportunity that a personal friend of mine is in the audience on this case, and I just wanted to say that that won't impair my ability to vote. But I think we all know you, so I'm not sure that we have to all say we know Mr. Sloan.
Thank you.
How many trees are you going to move?
Listen, he said they're going to save an oak. I don't know if you noticed that.
Well, actually,
the print's awful
Actually,
small,
if we can go back to the aerials, that if we have an aerial that shows the entire property, almost all of those, the trees that you see along the hills that back up to Fontenelle, even if you go back to our site plan, there.
Big one.
So no, the other one, that one. All of that you're seeing on the left side of the page, which is the western boundary and then sort of the northwest boundary, are hill-covered, steep topography, but covered in trees. And if the images that were being shown just a moment ago shows you how thick that area is. We don't intend on touching any of that.
Except the hackberries.
I'm sorry, where? Oh, no, the hackberries, so this not unusual that it looked like a farm because it has been a farm. And we have worked with TDEC, and we've worked with Metro Water, and we're repairing the stream that runs through it. Right now, as farms are apt to do, they just drive farm equipment back and forth and degrade the creeks, and so we're repairing those. We are removing some hackberries. We are moving some other invasive plants, but we're also adding a lot of vegetation, and we're also changing the soil type there so that it'll be much more absorbent. Right now, it's just been run over by cattle, and so it will be, as far as the stormwater management goes, it'll be a much better condition. It will hold the water a lot better than it does right now as far as how quickly does that all get into the stream. So from an ecological standpoint, this will be an improvement.
I'll just state for the record, Mr. Sloan just referenced my employer in his discussion, but I will advise that I had no idea of that involvement prior to this, and it will not impact my ability to cast a
Is he going to discuss your, what is it, the Nashville crayfish or whatever they call it that stopped the airport for a while?
No, we're not going to discuss the crayfish.
So it's 18 holes?
It is.
Par 72?
We're not sure yet.
We're not sure yet.
We're not sure yet.
Yeah, okay.
Okay.
Just trying to find new places to play. I mean, it doesn't hurt.
Any other questions for the appellant? Okay. I don't see anyone in opposition. So did you have anything else to add?
Absolutely not. I've found that in that condition, I should just be quiet and sit down.
That's right.
Quick when you're ahead, Doug.
We'll close the public hearing then and discussion.
Thank you, May I just add one thing that I neglected to mention, I think, whenever I was doing the presentation, which is that the planning department, you all have a recommendation that it be approved with the condition to minimize the tree removal and for the grading of the steep areas as well.
Thanks for that.
I make a motion that we approve the request with the conditions from the planning department.
Second.
Okay, we have a motion and a second. All in favor, say aye and raise your hand. That is 5 in approval, none against. That's approved.
Make motion to adjourn?
Yes, motion to adjourn.
Thank you.
All right.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.